Welcome everybody. Good morning. I'm a partner in our real estate team in Freeth's Leeds office. I've been through a few recessions in the property world, but nothing like this. Never have I experienced anything quite like this. Welcome to this webinar. We're going to be catching up on the current position as we go into the September quarter and beyond. This webinar follows on from our June webinar, which many of you may have watched. That was when the moratorium had just been extended until September 29th. When we planned this webinar, it was in August, so we had to assume that the moratorium was going to end on September 29th, so we called it Opportunities for Landlords and Tenants. We thought that tenants might have been in for a short, sharp shock as we went into October, but we also felt there might be opportunities for both parties. Obviously, it's no longer the situation, with the announcement of the extension of the moratorium just under a week ago. Nevertheless, we've got plenty to chat about today, particularly around the now popular insolvency types and how these impact on the landlord. I, for one, am looking forward to this part of the seminar because I'm frequently being asked about these concepts by both landlords and tenants. So let me introduce our speakers this morning in the running order we have for you over the next 30 minutes or so. We're going to kick off with Philip Myers, who'll be very well known to many of you watching this webinar. Phil heads our property litigation team in Yorkshire, and Phil gave us a very detailed analysis of all the landlord remedies and how they'd been curtailed in our June webinar. We won't be going through that again. We'll be picking out, as I've said, Phil will be sifting through the embers to see what tools are still available to the landlord. We're then moving on to our insolvency expert based in our Leeds office, Helen Bates. Helen will be breaking down the mystique of the terms administration and CVA to give landlords and tenants watching an idea of what rights are available to them when these situations occur. Last, but very much not least, we once again have Will Moroney joining us. Will is the head of property management at HBD, which is part of the Henry Boot PLC group of companies. Will give us his thoughts and experiences since the June quarter, and also his thoughts as we head into the September quarter, taking us into Christmas. Finally, we'll have time for questions, so please do line up a few questions for all of us. So, without any further delay, I'm going to hand the screen over to Phil. Good morning, Phil. Are you feeling positive, and have you got plenty to tell us?
Yes, I am feeling positive. I mean, I think the overarching thing is we will all get through this together. It will come to an end, I promise. So what I'm going to focus on really is the opportunities. Now, there's opportunities for landlords and tenants, and you know what's an opportunity for one may not necessarily be an opportunity for the other. I think the overarching sentiment remains as previous, which is, you know, we're in this together, so landlords and tenants should take every opportunity to talk, you know, and try and work things out if at all possible. Essentially, they need each other. You know, landlords don't have an income unless they've got tenants, and tenants don't have anywhere to occupy or to trade from physically, unless they, of course, they own the property, unless they have a landlord. So talking and coming to arrangements are the most important thing. Just to very quickly recap and maybe to explain, when we talk about the moratorium in this sense, we're talking about Section 82 of the Coronavirus Act, 2020, surprisingly. This essentially means that landlords cannot currently take action to forfeit leases for non-payment of rent, where the failure to pay rent is a consequence of the COVID-19 pandemic. Essentially, the non-payment of rent, whether or not it is as a result of the crisis or whether or not the tenant had problems previously, it's almost impossible to prove, and no doubt any difficulty will only have been exacerbated for the tenant due to the current pandemic. So as I say, it means the landlord can't forfeit either by peaceably re-entering the premises or by issuing proceedings for forfeiture. But I would also say the opportunity for the tenant is that the negotiations that take place between the parties can be quite free and open, because nothing that's said between them can waive the landlord's right, but equally it can't go against the tenant. And the courts have been quite understanding in their approach. So looking at opportunities for landlords, what can they do in this current climate? Well, first and foremost, there's nothing to prevent landlords from commencing court proceedings, either in the county or high court, depending upon the value of the debt, to obtain judgment ultimately for the arrears. Now, whether or not that's a good idea will depend upon the circumstances of the relationship between the parties. Obviously, once the landlord has started to sue its tenant, you can pretty much bet that their good relationship has come to an end. It may be appropriate if the landlord's got a tenant that simply won't pay, and won't negotiate, or won't cooperate whatsoever. It should be relatively straightforward to obtain a judgment on the basis that there's unlikely to be a defence because it's non-payment of rent. And once the landlord has the judgment debt, it can essentially sit on it and enforce it at a later stage, probably after this pandemic. And also, well, hang on, why would I issue proceedings? Because the debt continues to accrue. Well, depending upon how one, without getting too technical, pleadings, you can continue and ultimately get judgment for whatever's outstanding at the time when you obtain judgment. You potentially could leave an order open to claim more, but you'd need to go back to court. Or you can obtain your judgment and then sue again at a later stage when further arrears accrue. No, a judgment debt is only as good as the tenant's solvency. So, of course, and I'm not going to talk about insolvency, but you might have a judgment debt and then have a tenant that becomes insolvent and is pretty much useless. But you never know, and at least you have something there which is crystallised and crystallised your claim, and you can enforce it at a later stage. So the next thing that I'd like to mention, so it's not necessarily on the order on this slide, is drawing down on rent deposits. This is an opportunity really for tenants as well as landlords. If there's a rent deposit, landlords should look at that first. And the tenant, not necessarily required to look at it first, they don't have to draw down, but the tenant could point it out perhaps if the landlord's forgotten about it. Sometimes the deeds are put to one side and forgotten about. Indeed, the landlord, particularly if the tenant's potentially in problems and doesn't simply have the cash to pay, can look to draw down on that. Important for the landlord to follow the correct procedure, because there is a procedure generally for drawing down on the rent deposit, usually giving the tenant prior notice. But certainly have a look at rent deposits. It can be a good thing to at least reduce the amount of arrears that the tenants own. So that could be good for both of the parties there. Claiming against former tenants or former guarantors is quite pertinent, this, because well, just to start from the beginning, most leases are what we call new leases, and as many of you may know, tenants often assign leases because they may not want, they don't need the property, or for whatever reason, so they assign it to another tenant. In due course, the assignee may fail to pay, particularly with the current pandemic. So the landlord will be looking to see what it can recover. So where the assignment is part and parcel with an authorised guarantee agreement, in other words, the original tenant that's assigning the lease enters into an agreement with the landlord that it will guarantee any default of the assignee. It's not simply a case of the landlord just writing to the original tenant or any in the chain saying pay up. It has to serve what's called a Section 17 notice. I won't go into the boring detail of the legislation, but it's has to serve a notice on the assignor, the original assignor. But it has to serve that notice not more than or within 6 months of the rent arrears falling due. So, and if it misses that, if it doesn't serve it within the 6 month period, then that's it. It's lost its right to claim for those for the arrears that fell due at that particular point in time. Of course, when the next quarter or whatever arises, there's another rent arrears, it can then serve a Section 17 notice for those. But it has to serve within 6 months, as I say, if the rent or the fixed charge, as we call it, falling due. Now, 6 months is sort of relevant because the last quarter, of course, was 24th of March. So within 6 months would be today. So if there's anyone on this seminar who thinks that they may, who acts for landlords or is a landlord, who may need or want to serve a Section 17 notice on a former tenant or former guarantor under a lease, you need to really speak to a solicitor, ideally me, immediately after this seminar, because time is a ticking. I would say it's not impossible to do so, but it's we'd have to drop down tools and get a process server pretty much coming around to my house. But we can work magic. It's fine. So that deals with Section 17 notices. There is another potential recourse to recover rent arrears, which is called the Commercial Rent Arrears Recovery, or CRAR as it's more commonly known. It used to be essentially distress or distraint of goods. In other words, you get your bailiffs going around and seizing goods, normally taking what's called a walking possession order. You'll have seen it on Here Come the Bailiffs or whatever these programs are on Channel 5, which I unfortunately don't have enough time to watch. But they go around and seize goods. But there is a whole procedure that has to take place. First, you have to give the tenant not less than 8 days' notice. Now, the recent legislation in relation to the current pandemic has changed the amount of rent that must now be outstanding before a landlord can send round the bailiffs, as it were. Now, the regulations did originally include an increase in the minimum net unpaid rent that had to be outstanding before CRAR could be exercised, so equivalent of 90 days rent. Now, on the 24th of June of this year, that increased to a net minimum unpaid rent of 189 days. So that's as it is now, 189 days rent must be outstanding net. From the 29th of September, so next Tuesday, the amount increases that has to be unpaid rent to 276 days. And then from Christmas Day, I'm sure most of us have better things to do on Christmas Day, but that increases to 366 days net unpaid rent. So you'll see that the government are, rightly or wrongly, making it more difficult for landlords to instruct High Court enforcement officers, the bailiffs or the sheriffs, as colloquially they're sometimes known, to go around and seize goods, which obviously essentially means that a lot of the time the tenant simply can't trade and its business must close down because it's got no stock or computers or whatever it needs. So that's a major change. So I think I've covered all those points, I think, on the screen now, and say forfeiture currently cannot take place. The final thing that I'd like to mention on this point is the Code of Practice for Commercial Property Relationships during the COVID-19 pandemic. Whoever the government uses to think up titles for its codes of practice and guidance is a genius. Very snappy and short. Probably Boris. This was published on the 19th of June, and essentially this code of practice, which as I say is reference to commercial property relationships, really born out of retail originally, is mere guidance. It's not law, and it's really to encourage landlords and tenants to cooperate and to discuss and to act reasonably responsibly. The buzzwords in it, and to collaborate, and they've got to be transparent with other. But in other words, to work together to try and get through this crisis. In my own practice, I have seen a lot of concession arrangements, especially in relation to the March quarter's rent. So very much into April and May, I was busy drawing up concession arrangements whereby rent was deferred, or in very few instances they were let off. They had a complete sort of rent-free period for the first quarter, but most of the time it was deferment, and then often with time to pay back. I've seen many landlords and tenants come to me and say, well, this is what we agreed. And I said, well, great, where's your agreement in writing? Well, we didn't do that. Obviously, we just had a couple of phone calls. And I said, well, it's quite difficult then to enforce And then more sophisticated clients came to me and asked me to document those relationships. And I know that John will have seen that too, and other colleagues in the property teams. So we have documented them to ensure that they are binding and suable if either party breaches that. So before I finish my bit, I'd just be very interested to know, we've got a poll, how many, if any people on the call have in any way engaged with the code of practice, say that there's been the government's code of practice for commercial property arrangements. It's a simple yes or no answer. So all vote now.
Thanks, Phil. Whilst people are voting, I'm not going to let you off the hook quickly. I just wanted one point, which was the thing about suing, making your claims now and getting a judgment, because a lot of people are saying that's quite an important thing, even though you can't actually enforce at the minute. Helen will come to us about whether the moratorium on winding up petitions will be extended. But going back to you, I think you slightly underplayed it. I think people are saying, please use that enforcement remedy and get a judgment, so you're first in the queue when hopefully the shackles come off. Well,
yeah, that's right. And it's one of those things, though. It's better to do something than do nothing. And where your tenant's simply not cooperating, it can have a really good effect. I have seen on both sides where the tenants have got the cash, but rightly or wrongly, because morals doesn't come into this, they're using the cash for other reasons, probably to pay staff and to maintain their business. But when faced with a judgment which can affect their credit rating, might well be notifiable to creditors, lenders, etc., they will then pay, because at that stage they want to pay, they want to avoid it affecting their rating, and they want to avoid any further enforcement action being taken. And as you say, John, often those that get in first, subject to insolvency legislation, which we'll talk about, those that get in first obviously often get out, get their money out first as well. So and I know of some instances where clients have come to me where other lawyers have said, well, no, you can't sue, you can't go to court. You absolutely can. The courts are open, the backlogs are clearing, and we're very busy with this in particular at the moment.
Great. Thanks very much. Okay, over to you, Helen. Take us through the insolvency aspects.
Thanks, John. So I've been asked to give a bit of an overview today on CVAs and administrations and how they affect the landlord and tenant relationship, with these becoming increasingly common more recently. So CVAs are one of the hottest topics in the press right now. I don't think we can miss this. We've seen many household names. There's just a few of them on the slide there, but there are many, many household names which have proposed a CVA and where CVAs have been approved and they are now in a CVA. It's not a new concept, so this has been around since 1986 and it is commonly used. I think it's just coming more to the forefront right now because of the way it's been adapted to be more specific towards a landlord and tenant relationship. So one thing that you'll note from this slide is that the CVA is becoming increasingly common in relation to retail, leisure and hospitality. And these are typically companies where they have a large property portfolio. So there's a lot of leasehold properties that they have to deal with. So in terms of a CVA and what this is, the CVA itself stands for Company Voluntary Arrangement, and that's exactly what it is. It's an arrangement, and an arrangement between an insolvent company, and the company itself does need to be insolvent in order to do this. And the definition of insolvency is an inability to pay debts as and when they fall due. So it's not open to anyone who just simply wants to restructure their debts. It's only open to those companies that are technically insolvent at this time. It's a rescue tool. So it's there to help rescue this business. It probably needs a breathing space. It may have got some historic debts that it can't clear, but the underlying business is profitable and it just needs a bit of a breathing space or a bit of a restructure to be able to continue trading. So in terms of the process, the insolvent company identifies that it is insolvent and it comes up with a proposal to its unsecured creditors. Now, there's no hard and fast rule around what the proposal must be. It could be payment in full of the debts, but just over an extended period of time. It could be selling off some assets and time needed to sell off the assets to be able to pay its debts. Or it could be looking at paying just a proportion of debts over a period of time from trading profits. As I say, there's no hard and fast rule at all, so it can be anything quite creative in terms of what the proposal is going to be to the unsecured creditors to satisfy what they are owed, which may not be satisfying in full, it might just be a percentage. So the proposal itself will be a very lengthy document. Historically, you would have had this land on the doormat, but with ever evolving times, you might just receive a single page letter from an insolvency practitioner setting out a link to a website, and the link to the website will then take you through to the proposal itself. So do follow that link. It obviously does have a significant impact on you if your tenant does go into a CVA, and there are things that you might want to do about that, which we will come on to in a few moments. So once the proposal has gone out to the unsecured creditors and setting out what the company proposes to do, you'll get 14 days notice of a creditors meeting, and that's a meeting at which you as a creditor, as a landlord, and other creditors of the company vote on that proposal. And you're voting to either approve it, reject it, or to modify the CVA. Or as we will see in a few moments, you might just wish to abstain, but the purpose of the meeting is for the votes there. Now, in terms of approving the CVA at the creditors meeting, the votes need to total 75% in value of those voting in favour. Now, I say of those voting because even if everybody doesn't vote, you only count those that do. So if just one creditor votes and votes in favour, that will then result in the CVA being approved. You don't need to get 75% of everyone who's owed anything, it's just those who vote. And out of that 75%, at least 50% need to be unconnected with the company to vote through in favour. So you can't have these CVAs being forced through by connected intercompany creditors. Now, once approved, the CVA is binding on all unsecured creditor claims at the date of the meeting. The company will continue to trade. So the directors retain control of the business. They keep trading as they did before. All the supervisor does, which is an insolvency practitioner who will be assisting the company in putting the proposal together, and all that they will do is supervise the arrangement. So they just make sure that the company complies with what it said it would do in the proposal. They have no other involvement in the business. So there's no scope to investigate what went on previously, if there was any wrongdoing or if there wasn't. And there's no scope for a report to be made in terms of the director's conduct and looking at director disqualification. So the business very much continues as it was under the same management as before. And whilst it's binding on all unsecured creditors, the CVA won't affect secured or preferential creditors being the employee claims, and as of December, Revenue and Customs will come back into being one of those preferred creditors as well. The meeting itself, when that's held, it's held remotely. This is not a pandemic thing. The world of insolvency was ahead of the game on this one, so we've had remote meetings for a little while now. And voting can be done electronically ahead of the meeting, or there might be a virtual meeting similar to this meeting, what we're having now, but with there being a chat function available where everyone can see questions being put, the answers to those questions, and then a formal vote at the end. So moving on to the next slide. In terms of the impact of a CVA on the landlord and tenant situation, so as I've just explained, the CVA is binding. So once it's been approved, it's binding on the landlord. The landlord won't be able to take any enforcement action for debts due prior to the approval of that arrangement. In terms of any compromised debt, which is likely to be rent arrears and other debts due at the date of the meeting, they will be paid as per the terms of the arrangement. And as I say, there's no hard and fast rule as to what those terms must be. So depending on what the CVA proposal is, you may get paid periodically, or it may be a lump sum payment at the end of the CVA. It really depends on the terms of what the CVA itself are. In terms of recent developments, the Debenhams case is the one that's hit the headlines the most and is probably our leading case at the moment in relation to this. Now, in that CVA, it was one of the first ones we saw where suppliers were being treated differently to the landlords. So in that CVA, the suppliers were all being paid in full and were not being compromised in any way, and it was only the landlord and leasehold liabilities that were being compromised. And generally what that CVA sought to do was to reduce the rents. A lot of the properties were over rented, and it was reducing the rents back down to market value. Now, the landlords, I say the landlords weren't too happy with this. There was a challenge of the CVA after it was approved in court. So the landlords grouped together and made an application to court saying, this is not fair, we've been prejudiced, we want this CVA overturning. It was backed by Mike Ashley, and there are obviously various reasons as to why that may have been done. But the court looked at this and said, well, reducing the rent down to market rent is not unfair, because the alternative here is that the company could well go into another insolvency process. And if it does, you will probably lose your tenant and you won't get paid. So actually a reduction to market rent, and with everyone being reduced down, is not seen as being unfair. But what was seen as being unfair, and where the landlords did have a minor victory, is that the CVA had sought to prevent landlords from forfeiting the leases, and the court held that it can't do that. So in any CVA going forwards, you will retain the right to forfeit. What the CVA may do is alter the triggers for forfeiture. So if there are some contractual clauses which trigger forfeiture, they may be altered, but you will still retain that right to forfeit. And what we're seeing leading on from the Debenhams case, and there's a few others that have done similar as well, so Buzz Bingo, Travelodge, cases such as those, where the landlords are categorised. So you'll have category A, category B, category C. There'll be different properties, and the company will have identified that some of those premises are trading profitably, some are not. The leases are higher in some than in others, and they will treat those landlords differently in those groups. So category A, typically the landlord will be paid in full going forwards. Category B, C, D, going down, there'll be a sliding scale in terms of how they are treated differently and variations to the lease. So it might be changing to turnover rents, it might be monthly rent instead of quarterly, it might be a reduction of the rent. As I say, there's no hard and fast rule on what the proposal may be. So in terms of the options, once you receive a CVA from one of your tenants, what do you do with that? So as I said, you've got 14 days notice. So if you do need to take advice, you need to act relatively quickly. To consider your options and see what you can do. It's not necessarily a take it or leave it, and I have advised a few landlords on these recently where they're faced with a CVA and they think that that's it, it's a done deal, that's what's happening, and their hands are tied and there's nothing they can do. It's not necessarily the case. So you've got your 14 days, you can look to negotiate, you can look to propose modifications to the CVA. Now, I'm not sure if everyone's seen in the press the New Look CVA recently. It happened there. So at the initial meeting, it looked like the landlords were going to reject the CVA. The meeting was adjourned, so it can be adjourned for up to 14 days. And during that time, negotiations were had, and at the adjourned meeting, it was then approved. Saw that in relation to Buzz Bingo as well. There were a few adjustments in relation to certain categories of landlords, and the CVA was then approved when it came to the actual meeting. So do use that 14 days to look at what your options are and negotiate if you can. Now, in terms of your options, it will depend quite largely on where you feature in the voting. So as I said earlier, you need 75% of those voting to vote in favour. Now, within the CVA proposal, there'll be a statement of affairs. It will set out the assets and liabilities of the company. And in those liabilities, it will list all of the creditors, and you'll see your claim in there and how much has been allocated to you in terms of your claim. If you have 25% of the vote, you could block the CVA. So you could reject it, and you could then force that company into a different insolvency process. So you have quite a strong bargaining position to go back to the company and say, well, I've seen the proposal, but I don't like this particular aspect. Actually, what I want you to do is, if you trade profitably, I want you to ring fence a slush fund to then be distributed to creditors later on. For example, don't just reduce down the debt that's due to us and then you take advantage of the profit, actually share in any profit. Things along those lines could be looked at being negotiated. If you don't have 25%, you might see on that list other creditors that you know, or you might want to get in touch with them and join forces to get you to the 25%. And then if all else fails, when it comes to the meeting, you don't have to vote. So there's a choice to be made as to whether you do vote on it or whether you don't. Now, obviously, if the CVA, typically it will give a better result to you, or it will at least be dressed up as giving a better result to you. And as I say, do check those figures. The figures are often caveated and based on various formula, which might not necessarily be the case for you. So if it looks like the CVA is better than an administration for you, you might actively want to vote in favour. After all, you'll get to keep your tenant, and a paying tenant in the property is better than having the empty property there with empty property rates and looking for a new tenant. But if your vote doesn't actually make a difference, you might want to abstain. It's an evolving area of law. So previously there was a JJB case back in 2007. And back then it was seen that if as a landlord you voted in favour of the CVA, you definitely would be bound by its terms. But if you'd abstained, there was a question mark as to whether you were bound or not going forwards. So if your vote makes no difference, it might be best to simply abstain from the voting. Now, if you do wish to vote, the key thing is get your proof of debt, or it might be called notice of debt or notice of claim, and the proxy forms in time. So they need to be in before the decision date. And that basically sets out how much you're owed, how that debt has accrued, and who it is that you want to vote on your behalf, or how you wish to vote at that meeting. If you don't get those in, your vote won't count. Now, as Phil said, forfeiture and CRA, we've got it there on the slide, but at the moment there's obviously a prohibition on it, and that prohibition is lasting through to probably next year. Whether that gets extended or not remains to be seen. So little asterisks on there that you can't do this right now, but going forwards you may be able to. So if you receive a CVA, as I say, you've got that 14-day period. It may be in your interest to actually try and forfeit the lease quickly within those 14 days, or to exercise CRA. Again, it's something you probably want to take advice on at the time. You know, do come to us if that's the case, but do consider the option there if it's appropriate. And then finally, if the CVA is approved, it's not still necessarily the end of the road for you. You can still challenge that, similar to the Debenhams case. So 28 days from the date of the meeting for you to challenge that and make an application to court. You would need good grounds. Your grounds would need to show that you've been unfairly prejudiced in some way, so you've been treated worse than other creditors, or that actually you would get a better return in administration or liquidation, and therefore you shouldn't be bound by the CVA. So administrations, this is the other hot topic in the press, and is typically seen as being the alternative to CVAs. So if a CVA is not approved, generally the company will move into administration, and you will often see in a CVA proposal the comparison is between CVA and administration rather than liquidation, because administration is often the most appropriate alternative. Again, the company needs to be insolvent in order to be able to appoint an administrator. And if we could just move on to the next slide. So the administrator is an insolvency practitioner again, and is someone who will be appointed by either the company, its directors, a secured creditor, so qualifying floating charge holder, debenture holder typically, or a creditor through the court process. Unlike a CVA, where in a CVA the directors retain their powers and continue trading, in an administration the directors lose their powers. So they have no management powers whatsoever unless the administrators give them back. It's very rare for that to happen. We've seen it again, the Debenhams case, that it's classed as a light touch administration where the directors are still trading, but that's one of the rare cases. Typically the administrators take control. They act as agent of the company. They can keep trading it, and we do see that happen with some of the larger entities, or they may simply look to sell off the assets and then distribute the realisations from those assets to creditors. Typically your secured creditors will get paid out of the assets which they're secured over, and then all of the unsecured creditors, after preferential creditors are paid, will get a percentage, a pro rata equally. The objectives of administration are there on the slide, and they should be followed in that order. So the number one objective, and the whole reason administration was brought about, again, is a rescue tool. So the whole purpose is to try and rescue the company as a going concern. Now, this is very rare. I've seen it happen probably a handful of times in my whole career. Generally, what you will see as a result of an administration is just a better return to creditors than what you would see in a liquidation, or property being realised to distribute to a particular secured or preferential creditors. So as the landlord, you're likely to not be paid in full, potentially, as a result of the administration, and you may also lose the tenant. But moving on to the next slide, we can see just a summary there of the main points of how administration affects landlords and tenants. So the key one is the moratorium, and many people have come across this. So at the point of looking to appoint administrators, there will be a notice of intention to appoint filed at court, and then a notice of appointment. Both of those documents create a moratorium, prevents enforcement action. So you simply can't take enforcement action against the company. It gives the company a breathing space to try and restructure and trade its way out of this particular problem. So the enforcement action is prevented unless you can get the permission of the administrator or the permission of the court. So you would go to the administrator first, and if they say no, you can then apply to court, and the court will carry out a balancing exercise, and they will look at the landlord's interests as against the other creditors, and are you being put in a worse position, or actually is everyone suffering in a potentially similar way? And if everyone's suffering quite equally, you won't be able to enforce. So before doing that, again, it's worth taking advice just to see what the likelihood is of such a challenge being successful, because it is quite costly to do that. In terms of rent arrears, when a company goes into administration, you would feature just as an unsecured claim. So it's unlikely that you would be paid in full. This is obviously subject to the points that Phil said about whether you could go after a guarantor and whether there's a rent deposit. So they're separate issues. In terms of anything that you're trying to recover from the company itself, it's unsecured. You may be paid in full, but it's highly unlikely. What I would say, though, is always submit a claim. So similar to before, notice of claim, proof of debt, whichever form the insolvency practitioner in this case is using, submit that, because if there is a distribution of assets later on, you at least stand a chance then of receiving at least an element of what you're owed. The rent during the administration. Now, if the property is being used by the administrators for the purposes of the administration, you should then be paid the rent as an expense. Now, this is supposing there are sufficient funds within the administration to pay you, because obviously if there isn't enough money there, you don't get paid. But when you're paid as an expense, it means that you're paid ahead of the administrator's own fees. Now, I've been doing this game quite a while. I do not know many administrators who are willing to take on a case where they think there's a risk they might not get paid. So if they're using your property and they know they're going to have to pay you as an expense, there's a good chance the funds will be there and you will get paid. And that's quite a good outcome for you for that period of time. It will obviously only be for a short period of time whilst they either look for the buyer of a business. If the company is rescued, then fantastic. You know, you keep your tenant and everything stays on the same terms. But as I say, it's very rare. Or once they stop using the property, then that's the point at which you lose the entitlement to be paid. And then pre-packs is the other key area of administrations. So a pre-pack, just quickly, it means that a deal has been pre-packaged. So the company knows it's insolvent, it's going to appoint an administrator. The proposed administrator will start marketing the business and assets. We'll look for a buyer for those. If a buyer is found, negotiations will then be had over the terms of the sale. There may be various purchasers, it may only be part of the business that's sold, but if an agreement is reached, the documentation will be drawn up for the sale of the business and those assets, and that will then complete immediately upon the administrator's appointment. So it's pretty seamless. Typically what you will see there, if the company is wanting to keep trading from the property, the new company, the purchaser, is there'll be a license to occupy. Now again, even though the lease will probably say licenses to occupy can't be granted, you don't have the ability to enforce. So you can't do anything about that other than going to court for that challenge. But it's not a particularly bad scenario for you. You have a tenant in there. The new company will be obliged to keep paying you, and you then have the scope to negotiate an assignment or a new lease with that new company that's entered into the property. One thing that administrators can't do, which liquidators can, is disclaim a lease. So what you would typically see is if the property is no longer needed, the administrator will come to you and try to agree a surrender, or they might even post the keys back to you and say that that affects as a surrender. It's obviously something you'd want to take advice on at the time as to whether you want to accept the surrender. There is a duty to mitigate your losses. Can you relet the property elsewhere? You think you might struggle, you might actually want to keep the lease in place for a while, even though you're not being paid, to avoid the potential taxes on the grant of a new lease and empty property rates and those things. But again, it's something where you'd want to take advice at the time in terms of what's the best course of action for you to take at that point. And I'll now hand you back to John.
Thanks, Helen. That was excellent. Thank you very, very much. Lots of questions I'm sure will be raised on that. I always throw the pre-pack one out, and maybe we'll do that a bit later on. We have got a poll coming up now. I'm waiting for it to come up on screen. Okay, so we're going to ask the audience, have you been involved either as landlord or tenant in a CVA or administration through the COVID pandemic? Put a tick in whichever applies to your situation, and we'll have a chat about the results at the end of the webinar. Thank you. Okay. the final part of the webinar, we just, apart from question and answers, we're just going to have a bit of real life view. And I'm very pleased to say hello to Will Moroney again and welcome him to our webinar. So I'm going to ask Will a few questions and hopefully he's got some good answers for us. How are you, Will?
Morning, John. Yes, keeping well, thanks.
Good. Okay, well, my first one I'm going to ask you is the last time we spoke, we were going into the second quarter of potentially no income. We're now 6 months gone and going into 9 months, and the situation is possibly better, but still not perfect. Are you detecting strains from the varied occupiers in your portfolio? And can you tell us a bit about that?
Yeah, absolutely. I mean, personally, the last quarter sort of felt like a bit of a lull. Now, I don't know, possibly that's because we've had summer and people have been taking time off, or we've actually been getting back to some minor form of normality where people are getting on with business. In terms of our portfolio, and I think I stressed last time that yes, we don't have the biggest portfolio at the moment. We've now negotiated agreements with virtually all our tenants who hadn't been able to pay in perhaps March and or June. In terms of the collection rates themselves, March we were at 76%, June that was slightly better at 82%, and we're forecasting September at 88%. Some of the agreements that we've had with tenants are overpaying, I think, over an agreed period of time, so those collection rates will potentially step up a little bit more. We've seen the 8 Out to Help Out scheme, which sort of tried to kickstart the hospitality and leisure sectors, but was that just more of a sharp, short-term benefit to that industry? But I think generally tenants have been working really hard to make the best of the current situation, which even now keeps evolving. I mean, the latest set of restrictions imposed yesterday could be in place for 6 months. And if people are now being told to work from home again, high street footfall could be well down. And with so much uncertainty, potential local lockdowns, sectors could be hit regionally, which makes it harder for landlords to forecast and tenants to potentially keep up with pre-agreed payment plans. And also furlough. I mean, that's due to end at the end of October, although as with the moratorium, you can see this being extended in some form or other. And I believe the Chancellor's making a statement in Parliament today. Right.
Yeah, I agree. And I do agree that tenants have been working really hard to try and find a way through some of these difficulties. Just bearing in mind they've extended the moratorium. What are your thoughts from a landlord perspective on that extension until the end of this year? And would allowing market forces have been a better way to deal with things, or do you feel tenants really just aren't there yet?
It's not really a surprise that it's been extended, but once again, landlords are being hit hard. I mean, potentially this could be the third quarter now where some may not have collected any rent. And whilst a lot of that will be justified from tenants struggling, there are going to be companies out there, which I'm sure we've all heard about, that are using it as a bit of a loophole to preserve cash despite being able to afford rents. And they may also have benefited from some of the government grant schemes. I think where the government needs to sort of be a bit careful is putting landlords into the same bracket. Not all are big corporates with multi-million-pound portfolios. Some might just have the odd property as their pension. So restricting the ability to go after tenants is difficult for them even more so. And whilst it impacts on a landlord's ability to collect rents, we are still seeing a number of operators potentially looking down the insolvency route, which isn't good. This leaves us as property owners with various void costs, so a double whammy if you like. No rental income, but also having to pay for the upkeep of an empty property.
Yeah, I saw some talk of them getting rid of the even the existing 3-month rate-free period when a property becomes vacant. Don't know whether that's going to be abolished or not. Just a quick one. Tenant insolvency will only become more prevalent in my view. Have you thought about any strategies to deal with that within your portfolio? Are you comfortable with your own knowledge? I mean, I do feel to be a property manager at the moment is quite a difficult thing. There's so many different areas to look at. We talked about Section 17. What are your thoughts on that?
Well, hopefully we're in a position where we sort of know the strategies available, and even more so after that great summary from Helen, easy to follow breakdown of the possibilities that we can see as landlords. I don't disagree that we're likely to see insolvency more, be that now in the short term or even potentially moving forward into the next few years. When that happens, it's going to have a massive impact even more on the economy. We've seen threats of CVAs unless we look at taking surrenders of properties. And then sort of does it get into a bit of a game of chess there? We're threatening the CVA, Mr. Landlord, make your move. As a landlord, it's better to get something than nothing, or is the tenant bluffing? But as I mentioned earlier, if if you end up with a vacant property, you've got the associated costs of dealing with that. You've got the non-recoverable rates, insurance, security, service charge voids potentially. But that said, some landlords may have properties that actually they're not too upset to take back. If they've got a realistic option to re-let, that could be a situation that benefits both the landlord and the tenant, although those might be sort of few and far between. And you've just touched on one of the areas that the government, that they class as a loophole, is the temporary occupation of empty property. That would be a big concern for us. At the moment, you can temporarily occupy a property for 6 weeks, and then you'd get the 3 or 6 months relief, depending on the type of property. That helps us reduce our exposure and preserves cash. But to sort of take those out of, if the government are going to stop that, then landlords may even need to look at sort of making buildings uninhabitable, just so that they don't have to pay rates. And then when the economy recovers, there's going to be a shortage of available stock.
Yeah.
Our preference, though, is we sort of do want to continue working with tenants to find a resolution that works for both parties.
Yeah, great answer. Yeah, very interested on that temporary occupation part. So looking further ahead, the December quarter day could be very difficult. Presumably you've got a good idea of where the difficulties will be in your portfolio, and will have already been drawing up a strategy for dealing with those tenants well before that time.
I always tell our board that all quarter days are difficult. This year more so than ever. When lockdown started back in March, we did some forecasting for the year, and touch wood, we're not in as bad a position as we'd forecast. I think it was easy to potentially be ultra cautious, but at the same time it had to be realistic. We've been fortunate though, because we've had a great buy-in from tenants, and we've worked really well together. I think all but one of the properties in our portfolio now, we're actually both in a position where we know how we're moving forward. But a lot will depend on the measures being implemented by the government. I mean, with localised lockdowns, threat of wider national lockdowns, although I can't see the economy wanting to be shut down again. But restrictions are going to have some major fallouts for various sectors, leisure in particular.
Yeah, agreed. My final point is, you know, from what you've been saying, the one thing that comes through, and I totally agree, you know, we look at this sort of battleground between landlords and tenants, it's all about relationships. And presumably you've been developing relationships, not just over the last 6 months, but probably longer, with your opposite numbers at the various companies. And you can speak to them with some sort of honesty to find out really where they are and what's going on.
Absolutely. I mean, our approach, even before COVID, has always been about that relationship management. And then when you do find yourselves in these types of situations, those relationships really come to the fore. I think honesty is key from both sides. And when we've been looking at having discussions with tenants, we can feel satisfied that they're being honest, and hopefully that they feel as though they're getting the same from us.
Right. Thank you very, very much. Excellent as always, some great thoughts in there. We're going to have, sorry, we've had our final, no, we're going to have another poll, aren't we? If we can put it up on screen. Just talking, we didn't touch very much on lenders, but obviously they're pretty key to many landlords and what attitude they're taking on loan to values and things like that. Have you found your lenders sympathetic and prepared to work with you, or are they sticking to their terms and their facility letters? Yes, no, or you don't have a funder? Please vote now. I'm going to hand back to Phil, and you're going to deal with Q&A, Phil, aren't you?
I'll deal with Q&A, yeah, and then no doubt we'll do the poll results after Q&A. In no particular order, we've had some really interesting and some insightful questions here. So this one's for Helen. Can you please explain the property category classification? Should that be based on income from that property? For example, we pay the landlord the full rent on a prime site, or could we still negotiate to pay less because the whole portfolio is stretched?
Okay, so I assume this is in relation to, excuse me, the CVAs, and the way that at the moment we're seeing them being structured with different landlords being categorised differently. It comes back to the point, there's no hard and fast rule. So if you're putting forward a proposal yourself as a tenant and you're looking at categorising your different landlords, chances are you'll have had a surveyor or some expert of some sort looking at what the market rents are for those properties, what realistically the rents could be reduced down to, so that it's not then seen as being unfair on a particular landlord. In terms of, can you reduce rents across the board because the company is struggling, yes, that's something you can put forward. Whether the landlords will accept it or not, obviously it's a matter, you have those 14 days to negotiate. And as I say, the creditors meeting can be adjourned for 14 days for further time. So there is a negotiation to be had there, but the proposal is very much the insolvent company's proposal. It's what it is proposing to its landlords, to its other creditors. So no hard and fast rule on how that's approached. It just needs to be seen as being fair. And if it's not seen as being fair or unfairly prejudicing one particular landlord or one particular class of landlords, there's a risk it might get challenged in court. But yes, a reduction could be made across the board.
Excellent. Another question we've had in, might be a bit for me and Helen. If the restriction on serving a winding up petition doesn't get extended, so you know it's sure to expire, then presumably this will significantly strengthen the landlord's position. How quickly would it take to move from judgment debt to winding up order in today's court process with the delays that are going on? The bit that I would say is you've got your judgment debt. You don't need to, and Helen correctly, that on the basis that it's against a company, to be £750 or more, you don't have to serve a statutory demand before pressing ahead with the winding up petition. Many people do because it's sort of a last throw of the dice, a last attempt, and it's quite cheap to get a stat demand served. You know, it's not really a court process in itself. It's a form that we fill in, Helen will fill in, and it's served on the debtor by a process server usually. So assuming that you don't get anywhere with that, how quickly can we get a winding up order? I think I'll move now to Helen.
So in terms of how long is a piece of string, so you're absolutely right, Phil. You don't need to do a stat demand beforehand. You don't even need the judgment. I think as Phil was saying earlier, you would issue proceedings right now because it's one of the few tools left available to you, and it's better to do something than nothing. But even without a judgment, what I would be saying is at the moment, the prohibition is not being extended. I don't doubt it will be. I anticipate we will hear something later this week or early next. But on the basis that it might not be, what you might want to be doing right now is sending a letter of demand to your debtor and saying to them, if you do not pay, we will assume that you're unable to pay your debts as and when they failed you. You're therefore insolvent, and we will be presenting a winding up petition on the first available day, which is the 1st of October. Now, assuming that the prohibition isn't extended on the 1st of October, you could then present that petition. Now, we know there's a backlog with the courts. It's just been announced this morning that some more Nightingale courts are being opened. So York's having the Hilton Hotel converted into a Nightingale court. So that will hopefully clear some of the backlog. In normal times, I would say between presenting the petition and getting the winding up order, you'd be looking at somewhere between probably 4 and 8 weeks, depending on how busy the court is. Now, as I say, how long's a piece of string? The world and his wife are probably going to be presenting petitions all at once. If we are all working from home, that's the court staff as well. It might take them longer to process the petition, so it might be a lot longer before you actually get notice of the hearing, let alone when the court has got space in its diary to actually hear the petition. You could be looking at months before you actually get to the order. It's very much an unknown, I'm afraid.
Okay, thanks for that. Another one, is there a downside, this is for me I guess, is there a downside to serving a section 17 notice on a former tenant or guarantor? You know, were there any things, you know, any reason why you shouldn't do it? No, and you can serve more than one section 17 notice. You can serve it on maybe more than one former tenant, more than one former guarantor. Any former party can make an application for what's called an overriding lease. In other words, a lease for essentially on the same terms the remainder of the term. You know, the landlord will say, well, actually, I don't want another former tenant to be my ongoing tenant. But I guess in the current marketplace, having a tenant, whoever that might be, is probably better than having a void, a vacant property. So. But no, there probably isn't any downside on that. So that really concludes the questions that we've had. Some interesting ones there. Now the poll results that we're all excited to hear. I don't know whether they're going to come up on the screen or whether we're going to read them out. But
read them out, Phil.
I'll read them out. So the first poll related to, if you recall, the code of practice for commercial property. Whether or not those on the seminar have used it. Unsurprisingly, 27% say no. Sorry, 27% say yes. So not many people have used it, and 73% of people have said no. And that really, of course, is what I've seen in practice. The code is just a code. It's toothless, frankly. When I'm acting for tenants, I tend to cite it in correspondence, but it's probably not relevant in any subsequent proceedings. I would have thought may come down, maybe in relation to this year's costs if it ever gets to that stage. Poll 2, that was whether any of you have been involved in a CVA or administration, or neither. Those involved in the CVA, this is during the current coronavirus pandemic, of course. 29% said CVA, 14% have been involved in the administration. The majority, 71%, is neither. And then finally, the last poll that we just had on whether or not those dealing with lenders found those lenders to be sympathetic. 66% have taken the no fund of Oxford, so they haven't had any involvement. But interestingly, the remainder, 17% each, the math is correct, it is correct, whether the lenders have been sympathetic have said yes and no. So pretty much 50-50 on whether or not lenders have been sympathetic. I'd be interested to know which lenders are more sympathetic than others, and we could share that information. I'm not sure we have that to hand. I'll say thank you to everyone, and I'll hand back to John.
Yes, just want to say thank you for everybody who attended. Hope you've got something out of it. We're probably going to look at it again in December. I just want to say a big thank you to all the speakers who have been absolutely excellent, and a special thank you to Will Moroney for once again taking some time out to come and join us and chat about what's going on in the real world. So thank you all very much. Goodbye.